All right. Hi, everyone. Thank you for tuning in tonight. We'll just give people a little time to join in and catch the live, and then we'll get started. All right. Hi.
Hello, hello.
I'm just sharing it to other pages so that people
I'm doing the same. It's like, what? She's like, everybody's like, why is she looking over like that?
I know. Hey,
All
Shaquille.
these devices.
Thank you guys for tuning in. We won't keep you super long tonight, but just wanted to make sure we were keeping people abreast of what some of the things that are happening in the city. So if you don't know me, my name is Ashley Hines, and I'm the executive director for an organization called the Benton Harbor Community Development Corporation. We are a nonprofit organization that coming up on our 2-year birthday, who's dedicated to revitalizing the city of Benton Harbor from a holistic approach. And so we help to develop people as well as infrastructure. And so a lot of our work focuses in the Empire Corridor neighborhood. So that Empire Broadway area of the city that to a lot of people is really the heart and soul of this community. A lot of people have a special affinity to that space. And so is no stranger. A lot of you will probably be no stranger to what we're talking about here today. So across the street from BJ's, there is a property that has been um, vacant for a number of years, but traditionally served as a hub for a lot of Black businesses, including one that was owned by my father at one point, a clothing store right at the corner. But next to that sat Lady T's barber shop. And so I want to introduce our guest tonight, Attorney Elizabeth McCree, who is a daughter of Benton Harbor, but also specializes in children's law and basic estate planning and probate as well. And so Elizabeth, can you tell us a little bit about Lady T and how you became involved in her case?
Sure. And thank you for having me. I know that originally I said I was going to wait to talk with you or wait to say anything publicly because of the fact that this is ongoing litigation in regards to Lady T's case. But I think that it's important enough in regards to what's happening and what I've heard city officials saying that it needs to be addressed now. So that's why I agreed to come on with you. I've known Lady T my entire life, and I went to Lady T's barbershop for a good majority of my childhood to get my hair done. Myself and my mother. My cousin Lyman worked there for years as a barber and hairstylist, and Sylvia Weisinger, who has since passed, she was my hairstylist for many, many years. And I actually established a fund at the Readiness Center, who I'm a board member of the Readiness Center for her because she was a parent over at the Readiness Center. So I have a long-standing relationship with many of the people who have worked and made their lives and their livelihoods in that building. But Lady T is a special person to me, and she always has been. She was a mentor for me. She was somebody who always championed me when I lived in Georgia for 12 years, when I went to undergrad and law school. Came back practicing law. She was always somebody who was a support to me. She's an amazing woman. And she's a longtime property owner and business owner in that area. Before it was just Lady T's, it was her and her husband who had the barbershop there, last name Fleming. And her son's last name is Wesley. So you may have seen us talking about Wesley, and that's her son. So Lady T, Lady Taylor, and with her second husband, she changed her last name to Taylor, and that's where you get Lady T's. But Lady T's was a staple for many years. Many people got their hair done there. Many people came, and what the barbershop is in the community as far as also being kind of the therapy spot and everything else. So Lady T's definitely was that place for a long time. Particularly becoming involved in this case is I assisted with some estate planning for Lady T when she became ill. And she's been suffering from some different things for a while. She had strokes, and now is facing some additional battles. And so in doing the estate planning, I get a call from Wesley that basically says, "Hey, I need your help with this stuff over at the courthouse." And I was like, "What do you mean?" And he said, I don't know what all these letters mean, but I've been trying to work this out with Meeks Construction. And now they're telling me that I need to go to court, or that, Lady T needs to go to court. And I asked them to send me the documents. And when I saw it, I saw that she'd been charged with a misdemeanor, criminal misdemeanor. And, I've done criminal law work for years. It's solely what I did when I was in Georgia for the time that I was in Georgia. And I still do criminal law today. And so when I saw that, I immediately knew what it was and said, oh no, this is not acceptable. She had already been appointed the public defender's office to represent her. This was after Wesley had appeared for a couple of hearings on her behalf. And so I substituted for the public defender's office on the case and have been counsel on the case since that time. But she is not the only person who has been charged. I do have an issue with who I have seen who has been charged and who has not been charged.
Yeah.
Which is part of my overall issue of fairness and due process that I've been raising.
Yeah.
But I am only representing Lady T in her case. So that's the only, specific case that I can speak to. I do know about some of the other issues with some of the other cases. The public defender's office has been very diligently working to try to represent many of the other people who have been charged as well.
Yeah. So can you tell us a little bit about the letter that Lady T and her family received and some of the contents of that letter, and then maybe some of the issues as well?
Sure. So I'll try to go through the timeline as best I can and try to be as succinct as I can. Sometimes it's hard for lawyers to do that. But my understanding is that the original notice or alleged notice by the city of Benton Harbor first came as a post onto the building in 2017. That is around the time that Lady T had been suffering from several of the strokes. And in doing that, they just posted something on the door of the building. So, and I just want to make this very clear, because I heard this being said multiple times at the commission meeting last night. The taxes on Lady T's building are up to date. They have always been up to date. She has not been deficient. So this is not a building that has not been on the tax rolls. This is not a building that's been owned by anybody else. It has been consistently owned by Lady T, at some point also her husband, but by Lady T and her husband for decades, and has been properly maintained as far as taxes are concerned. So anyway, in 2017, the notice came on the building, but nobody ever contacted the family in order to try to get inside the building to see what the building looked like, or give them any other options, such as coming to the planning commission or, discussing the state of the property or anything of that nature in 2017. During the pandemic in 2020, which, as we all know, a lot of different rules were kind of stretched as far as what you can and can't do in certain properties. It's my understanding that in 2020, which also kind of coincides with the reinstatement of the code procedures for the city of Benton Harbor, because during the shutdown, during the emergency management period, which if you get me on that, I'll be here forever about how horrendous that was, and I know many people agree. But anyway, the teeth in the code ordinances were removed by the emergency managers and continued throughout most of emergency management. And, so I know that, Mayor Muhammad mentioned that last night, and I agree that was horrible, because it made it difficult for the city to be able to do anything when you pull the teeth out of the code ordinances. So the code ordinances were updated. They've been discussing that ever since they came out of emergency management, and, as they've been going through other things. But in doing that, there was another notice apparently posted. Again, still no contact with the family or any contact with Lady T to try to figure out what was going on with her. So what prompted this round of issues was a letter that was dated June 25th of 2022 that was sent to her address.
January, right? Wasn't it January?
Sorry.
The date was January.
Yep, January 25th of 2022. It was received in February. That is from the Code Compliance Department. This letter that, as I've stated multiple times, is full of errors. And I can tell that it's a form letter that was sent out to multiple people. But in doing so, somebody didn't go in and check to make sure, for instance, there's different addresses listed in here that are not the address at question. Actually, the address that is actually Lady T's building is wrong on this letter. Nevertheless, it cites state Michigan code and the International Property Maintenance Code. So it's citing both federal and state law in regards to the fact, that they've considered the building to be condemned and dangerous and an unsafe structure. Again, when this letter was sent out, and to this day, to my understanding, no code official from the city of Benton Harbor has been inside the building. I know you have, so you can speak more to that at some point, but no code official from the city of Benton Harbor has been inside the building. But this letter in particular talks about the federal law and the state law and says that the property has to be demolished, that the structure is considered insufficient and has to be demolished within 90 days from the date of this letter. So again, that was on June 25th of 2022. Nowhere in this letter does it cite the code section, the Benton Harbor Code section, which is Chapter 25, Section 2, which is illustrative enumeration, which is what Lady T was eventually charged with. There's nothing in this letter that says, hey, if you don't comply within 90 days or any other time period in regards to that, we're going to charge you with a criminal misdemeanor. And when we charge you with that criminal misdemeanor, you're going to have to go to the Barron County Trial Court. There's no notice about that at all in this letter. Nor on any of the information that was allegedly posted on the building. And the only reason I know about anything allegedly being posted on the building is a couple of pictures that were attached apparently to the ticket that ended up being issued. It gives an appeal right with the the City of Benton Harbor Board of Appeals within 20 days of receiving the notice. The Benton Harbor Board of Appeals doesn't exist. That is not a thing. So, there's several different committees of the commissioners. There is an appeal board for taxes and different things of that nature. But as identified in this letter, going along with the federal and state law, the way that they tell you to appeal is not a process that actually exists.
Wow.
Go ahead.
I just want to touch on a couple points about this letter because I feel that it's important. First of all, the 90 days given to demo, that was the only option given to the family to be in compliance. So it wasn't like a list of things that could be fixed to rectify the situation. That was the only option given to this family, was to automatically demo. And so and then to do it in 90 days. And I don't know if the people who are tuning in have had any type of work done to their home. There are procedures in order to get things demoed, and that, quite frankly, I've been waiting on bids for properties for longer than 90 days in this city. So, that is virtually impossible to even happen here. And so, I'll let you continue on a little bit about the process, but I just wanted to note those things that, I question why demolition was the only option given to this family, particularly now that I've gone inside this building. I mean, even more so now, because Richard is in the comments, he checked out the roof for us, as opposed to the building next door to this, the one that my dad owned. So obviously I would want to keep that as well, to see that come back to life. But the roof has caved in. It is highly damaged. And I know that things like that can be brought back to life, but the reality is that they aren't facing the same repercussions that Lady T's building is. And so Lady T had recently had a roof put on her building, which ironically preserved a lot of the interior of the building, and definitely needs some work. And as you can see from the photos that I've been posting on social media, the awning that was it's not original to the building, it was added, that definitely needs to come off. But if you take that off, the structurally it's still pretty sound. And so I don't know why it was automatically deemed that this was the only solution to this property. So I'll pass things back over to you.
Yeah, I agree with that as well. And yes, demolition, it says in all bold in the middle of the letter, unsafe structure to be demolished. It doesn't give anything else. There's no list of, here are the things that you can do in order to bring the building up to what the code standards are. So that letter was January 25th of 2022. It was, I'm sorry, I see somebody says whose signature is on the letter. There is no signature on the letter. It's listed to be from Edwin Constable, building official. and it gives the 251 East Market Street address on the letter. So that was actually one of the things that I addressed in my motion as far as to electronic signatures and all that stuff. But, we may get into that later. That may be a little bit too much in the weeds. But anyway, again, this letter was dated January 25th of 2022. As soon as Wesley, Lady T's son, received the letter, he contacted Mr. Meeks Sr. with Meeks Construction and in February, went to meet with city officials about what he could do in order to address the letter. Essentially, what they were trying to do was do the appeal within 20 days that is discussed in the letter. Again, with the organization that doesn't actually exist, but nevertheless, they met with multiple city officials and they said, okay, we'll demolish the building. We have some arguments here, but Lady T has been facing health issues. They're trying to get a bunch of other things done. So, okay, we'll try to demolish it as soon as we can. And so they gave Wesley a lot of paperwork to do on his own, as far as confirming shutoff notices and different things of that nature. And, as he tried to fill it out himself, he wasn't able to do that. And, finally they told him, well, actually the contractor is supposed to do this. And he was like, well, I went with Mr. Meeks, but I haven't formally engaged him as a contractor. You all didn't tell me during the meeting that I even needed to do that to address the issue. So then Donnie Meeks Jr., who I call Jay, he said he came on board and said that he would assist. And the point that you made is very important. A lot of people aren't willing, a lot of companies are not willing to demo in the city of Benton Harbor for private people because the cost of the time that it's going to take, the value of the buildings due to devaluing with many different things that have gone on as far as property taxes and things of that nature, it's not worth it for them financially as opposed to doing other jobs and other jobs that are considered bigger jobs. So the Meeks Construction Company is the only company that really even agreed to work with Wesley in order to get this done. It wasn't a situation of, we had people knocking down the door in order to help build our bid. Then the next thing that happened is that there was another appearance in the mail, and that was this state of Michigan uniform citation that was issued. The date on this citation is March 28th of 2002. Now, again, January 25th, 2022 was supposed to be given 90 days. That would be the end of April of 2022. At the end of March, there was a citation issued, and that was issued by Code Inspection Officer William Snyder. It was authorized by the city attorney, which it states, it's handwritten on here. It says 4/20/2022. And then it says authorized, and it has the initials of the city attorney, who also serves as the prosecutor for criminal misdemeanors. So again, authorized on 4/20/2022 is still before the 90-day expiration of the January 25th, 2002 letter.
So they issue a ticket and authorize it prior to her deadline to demolition even expiring.
Exactly. And the appearance date on this document is 4/19 of 2022. So the appearance date was a day before it was actually authorized by the city attorney.
So what does the appearance date mean? Can you explain?
For you to come to the trial court in Berrien County to face these misdemeanor charges. And it says on here that it is a misdemeanor charge. The box for misdemeanor is checked. It could say civil infraction. It could say felony. It could say warning. It could say several different things. The box here, misdemeanor, is the box that is checked on here.
So I just want to note a couple things that you said for those of you who may not have caught it, because there's been a lot of back and forth. So we want to clear up any misconceptions or any just false information that's out there. So it was in fact a misdemeanor criminal offense. In addition to the fact that it was issued prior to her deadline expiring, it was authorized after the date that she was even scheduled to appear in court. So just a lot of different issues that are happening here.
Right. And the authorization after the initial appearance date is not necessarily out of criminal procedure. So if an officer charges somebody with a suspended license and gives them a ticket as opposed to taking them to jail, which is really kind of what is happening now during the pandemic. And really, it's up to the officer. They can arrest you, or they can say, do you have another driver, take the car home, or whatever the case may be. But you get a ticket that says you need to appear within 10 days, or it's going to have a date that's it's stated on the ticket. And then once you get there, sometimes the prosecutor, whether that be a city prosecutor or, somebody working for the county, they may look at it before arraignment, they may not. Most of the time, the prosecutor is not even there at arraignment when you initially come. So that in itself is not against criminal procedure, but it is criminal procedure, which is part of the point that I wanted people to understand is this is a criminal misdemeanor. It is not a civil infraction. So, and nevertheless, 419, 420, and the original date of the ticket of 328 are well before the deadline of the 90 days of the letter from January 25th. That again does not state to people that if they are not in compliance, they could be charged with a criminal misdemeanor.
Yeah.
Does not mention that at all.
Yeah. And so that's really important as well, because I think that because of this, quite frankly, outrage about this procedure, I want to be clear that the outrage is not because the city wants to hold people accountable for blight. That's what we want them to do. But there are serious flaws with the procedure as it relates to the ordinance and the steps that it takes to get people to be in compliance. And so that is what we're trying to call out here. That is the issue that the city should address, because it has gotten a lot of people in a really dire situation, not necessarily as far as their criminal record, but there are people who are really who have lost or could lose their property because of this. And historically, we know that there are ordinances like these who have traditionally been the cause of Black landowners losing their property, quite frankly, because of these loopholes type of situations and procedures. And so it's important to get this right, and it's important for the city to rectify this situation. So
yeah. And there's a couple of things I want to address as far as that's concerned, because I agree with you wholeheartedly. I'm from Benton Harbor. I don't want to see blighted buildings. When I came back after 12 years of living in Georgia, and drove around to some of the areas that, my friends used to live in and different things, I was, it was very sad to see the condition of certain things. And, like I said, I'll be the number one person to talk about the horrendous emergency management law and how, the things that it did to the city of Benton Harbor. But part of coming out of that, when we look at legislation, and I talk about this with my students at Andrews and everything else, is what is the purpose of legislation? What is the purpose? In fact, last week we talked about the fact that, the court is supposed to be impartial. It sits there and waits for people to come to it. The court doesn't go out looking for cases. The court doesn't go out, asking for things to be done. They're the arbitrator when other people come. Mm-hmm. So the city of Benton Harbor has come to the court in bringing these people to prosecution for these charges. And in doing so, they need to have a procedure in order to address these concerns properly, so that people's federal and state due process rights are being addressed. And the attorney said on Monday during the motion hearing that none of the properties that have been involved in these criminal charges have been demolished. So there are people who have pled to the charges. I know particularly of one case being represented now by the public defender's office, where they're trying to withdraw the plea because the person was not properly notified at the time of their plea that demolition was going to be required as part of the code ordinance. And so then was going to be a part of their plea that they demolish the property. And again, the city can come in according to the code ordinance and do it themselves, but they're trying to make the people pay in order to do this on their own right now, who have already pled to these charges. So not only are you paying fines and costs to the court for the prosecution of the case as the arbitrator for this case, but now you're also requiring them to demolish the properties, and none of them have been done. So if these cases started in March of 2022, and we are sitting here in October of 2022, and none of the properties have been demolished, then what is the goal of both the legislation as far as the code is concerned and the prosecution of these cases. Nothing
Exactly.
is happening.
Yeah,
So it's
nothing is
not addressing
happening.
the issue.
Yeah, it speaks so much to the process on this from the city perspective and from the owner's perspective of having to even go through the process and find people who are able to do it in a lot of timeline. It's just like it's virtually impossible to do it in 90 days. So
Right.
yeah.
And so what they have done in our case in particular is say, well, all we want is compliance. That's what I keep hearing from everybody. All we want is compliance. All we want is compliance. So we'll just continue to reset the case and continue to reset the case in order for compliance to be achieved.
Mhm.
Well, don't forget the national stories and headlines that we've seen about criminal charges in general, with the fact that many people end up entering pleas to charges, and 90% of cases result in a plea because one of the main factors is they have to keep coming back to court. So if I have to come to court for 6 and 7 status conferences, after a while, I can't take off of work anymore. I'm doing all of this in order to try to address the charges, meeting with my attorney, doing all these other things, much less trying to go through the process to get everything demolished. I listened to the hearing on Thursday, and they talked about the fact that the asbestos testing that is required by the city before they can do demolition, that they're behind on 46 properties for asbestos testing that are owned by the city of Benton Harbor. So if that needs to be done by the city officials, which places do you think they're going to do first? The ones owned by the city or the ones owned by these private individuals who have either pled or are pending charges? Who's going to get priority to get that paperwork done? No contractor can come in and demolish that building legally without having that asbestos clearance. In our case, we couldn't get the clearance from AEP that the electricity was shut off. And that was very interesting. I want to talk about that right now. That
So
was
give me
very
10
interesting.
seconds before you get into that, because
Okay.
I definitely want people to hear about that because it's so important. And I'm not a conspiracy theorist, but where there's smoke, there's fire to me. But I want to talk a little bit about the fact that for Lady T's property in particular, her family agreed to demolition. And they did that because that was the only option given, and they felt like that was the only solution. And the
Right.
issue is that there are resources available for people who would like to do this type of development and rehabilitation work in this community. And a lot of times we talk about the resources that are going to other areas in the city, particularly downtown. These same resources can be tapped to funnel into these types of properties. And so I just want to be clear that they agreed to do this primarily because that was the only option given. So when we talk about compliance now, as it's written, a lot of it was said yesterday. We just want compliance. We just want compliance. Compliance, as it relates to the letter and the ticket, is to demo the property, which the family, now knowing that they have all of these resources that could be available to them, they do not want to see it happen. And when we talk about equity building for people of this community, you have people who are legacy residents who own property. We want to ensure that they are able to keep this in their family to build generational wealth. And so to demolish this building, that to me is this historical structure in our community that can serve as a catalyst for change and development in that Empire corridor, is just virtually foolish. And so last night, the city manager, who I'm going to put his email up right now so that you guys, if you feel inclined, please feel to reach out to the city. He did say to me, because he overheard me saying that we checked out the building. It is very sound. It can be saved. I'm not sure what the procedure was to determine that this building needed to be condemned, but other than the awning that could be easily removed, the building is very sound. And he said that he will have someone to check it out today in order to he just said he was going to have someone check it out today and get back to me. I have not heard from them. I emailed the entire body today, as well as the city manager, the economic development director, the attorney, public safety, everyone, to kind of follow up on that and really asking for, compliance. It was said that it was compliance. Right now, compliance means demolition. You guys said that you are interested in having this building stand as well, and to see it become this new life in this community. What are the things that we can do in order to bring that compliance? And so I have not heard back. I'm urging people of this community to send emails to Ellis Mitchell as well to see what can be done to get this building where it needs to be in order to remove it from condemned status and drop the charges against Lady T. And I'm going to leave that up for a while.
And I want to address this because I don't disagree with you in saying that we made the decision to demolish, right? But it's a decision under duress.
Exactly.
It's not really a decision. You know, once you fall under chapter 25 of the code ordinance of the city of Benton Harbor, it's very clear, you know, as far as to the different sections, and you know that's the only option as far as abatement is concerned,
Yeah.
because it doesn't state, you know, that abatement and what the definition of abatement actually is. It
Yeah.
states that abatement is essentially getting rid of whatever the nuisance is, because the chapter 25 is entitled nuisances.
And if you Google Benton Harbor code ordinance, this will all come up, and it's broken down by chapter, like hyperlink. So you can just click on chapter 25 and it'll come right up.
Yes, and that's where I got this from when I included it as an exhibit. I got it from the city's website. So I won't go into it too much. I won't teach a lesson on it, but I do want to discuss chapter 25 and what was actually charged, if that's okay.
Yeah.
Okay. So the ticket that was issued, the charge that is listed, and the charge that everyone is dealing with who's been charged with this is under section 25.2, which is called illustrative enumeration. That's the title of that section. And that says the maintaining, using, placing, depositing, leaving, or permitting to be or remain on any public or private property of any of the following items, conditions, or actions are hereby declared to be and constitute a nuisance. Provided, however, this enumeration shall not be deemed or construed to be conclusive, limiting, or restrictive. That is the language. It then lists 12 different sections in which a property can be determined to be a nuisance. Noxious weeds, harborage for rats, mice, snakes, or other vermin. There's, you know, all kinds of dense smoke, accumulation of tree debris, tree waste, tree branches or limbs, you know, many different things, accumulation of rubbish, trash, junk, other abandoned materials. And I'm reading through all these. Number 4 is what the city attorney cited yesterday during the motion. This is the first time that he's actually particularly cited that, because I kept saying we have not been put on proper notice as to what you're even alleging Lady T's property has done wrong to fall under the level of nuisance. So yesterday he said it was subsection 4 of 25.2. That reads in full: any building or other structure which is in a dilapidated condition that it is unfit for human habitation, are kept in such an unsanitary condition that it is a menace to the health of the people residing in the vicinity thereof, or presents a more than ordinary dangerous fire hazard in the vicinity where it is located. That is the language in full. You've seen the pictures. I agree that the awning needs to come down. He at one point said pieces of the awning were falling on the street. There's no documentation of any of that, but nevertheless, the awning needing to be taken down or replaced does not fall into subsection 4 of section 25.2 of the code.
Right.
And none of them have been in that building. You know, you've been in that building, Ashley. The building is not in such a dilapidated condition that it is unfit for human habitation. Not to mention the fact it's not a personal residence, it's a business. So nobody is habitating within that business in the first place. It doesn't even fall. There should be, you know, if you're going to have separate sections for this, it should talk about commercial versus residential property in the first place.
Right. Right.
My argument to the court was, we don't need, you know, when we go to trial on this, because right now that's what we're set for, is for trial. If he's saying that this is falling under section 25.2 subsection 4, she's not guilty anyway.
Right. Yeah.
So, you know, and the other part of this is, I believe that section 25.2 actually should fall into section 25.1, which is a definition section, which you always have a definition section at the beginning of the code. It's just listing a definition of what it's believed to be a nuisance. Section 25.3 entitled prohibited is where it actually says it shall be unlawful for any person to cause, permit, maintain, or allow the creation or maintenance of a nuisance.
Yeah.
And that's not what she's charged under. And my students at Andrews will tell you that for any criminal offense, you have to have actus reus and you have to have mens rea. Actus reus is the actual act. So what they're trying to say is she's violated subsection 4. She hasn't. But the other part of that for a criminal misdemeanor is that you have to have a criminal intent to commit the crime. It's not a strict liability charge like driving without a license is, or, whatever, you have to have intent.
Yeah.
There's no intent to commit a crime in the
Yeah.
condition of a building for a woman who's had multiple strokes.
And I will say too, just to kind of bring light to the fact that this is an issue, like a lot of the commissioners admitted or said last night that they know that this ordinance needs to be changed. It is an issue. And so to continue to try to prosecute people based off something that is knowingly flawed, to me, it just does not seem right. And I also want to note that a lot of the city commissioners did not know the extent of what was happening with people's cases, and weren't familiar with what was happening in detail with Lady C's case. A lot of them found out because I brought it to their attention, and they have been advocating in that space. But ultimately, the city manager is the person who's responsible for being able to tell the city attorney, hey, you need to drop these charges. And so they've been advocating on our behalf, but unfortunately, we just haven't had enough progress with that. So I don't know if you have more to say about the ordinance, but I really want to get into the AEP situation.
Yeah, just a few more things on the ordinance. The next
Okay.
section 25.4, notice to abate, actually says whenever a nuisance is found to exist within the city manager or some other duly designated officer of the city manager or some other duly designated officer of the city shall give 3 days written notice to the owner or occupant of the property upon which the nuisance exists or upon the person causing or maintaining the nuisance. Any nuisance which exists or is placed or any tree lawn shall be abated within 24 hours of the notice. Again, that goes back to what we talked about. That's not even, nobody can do that. Even in a perfect world, that doesn't even happen. The person who they designate to do this is the code compliance officer. Part of my part of my evidence for the motion was multiple emails from Mr. Snyder, who was the code compliance officer, who actually issued this ticket, telling the city attorney to dismiss the ticket because he had met with Wesley and with Mr. Meeks, and the prosecutor still did not do so. The prosecutor can dismiss this case at any time. I've given him tried to have conversations with him in order to have a discussion about doing that, and he has not done so. I have notified the city. People who are my friends on Facebook have seen, and even who are not, because they were public posts, each hearing that I've been a part of this case have posted about the issues in regards to the prosecution of this case. And as I stated last night at the commission meeting, every single one of the commissioners and the mayor are my friends on Facebook. So I know that they have seen it and heard about this. And I will say this, and you know that I champion the work that you do, Ashley, in your organization. But the idea of at the final hour trying to work some type of deal and have that deal essentially say sign the property over to the Community Development Corporation or to AEP or to anybody else, again, is a decision that would be made out of duress.
Right.
Of somebody who's facing a criminal charge.
Yeah.
And I do want to mention this as well, because the maximum possible penalty for this charge is 90 days in jail and a $500 fine. Yesterday, the mayor asked the city attorney if anybody has been sentenced to jail on any of these charges, and he said no. That may or may not be true. I don't know. I don't have the statistics. I haven't done a FOIA to find it. But what I want to follow up with, and which I wish I would have been able to follow up with, is asking him how many people have been show caused because of this, or how many people have had probation violations because of these charges and ended up in jail because of the show cause or the probation violation. Anybody who knows about the way that criminal law works and criminal procedure works in this country, and Berrien County is not immune from it, is that people most often end up going to jail because of probation violation or show cause, failure to pay fines, or failure to rectify the situation. So now we have a situation where none of these properties have been demolished. They're going to start getting show cause because of this. So that answer is not sufficient to address the fact that the maximum possible penalty here is 90 days and or a $500 fine. Anyway, AEP, after the first hearing in the case, I was contacted by the right-of-way agent for AEP. And this gentleman said that he had been out to the home and met Wesley, and Wesley gave him my information. And they said they sent me an email that had a deed attached to it and said, we are willing to pay to demolish the property because of this project that AEP is doing in regards to substations and updating power systems. And he sent me an attachment that included a map of Benton Harbor City, Township, into some of the other townships of this huge thing that AEP is planning over in order to try to improve power lines. And I responded to him, well, that this is interesting. And, you know, I'm looking at this. I said, but we can't do anything right now because right now Lady T is still facing criminal charges. And even if we were to sign the property off to someone else, that does not change the fact that on the date of the ticket, you know, March 28th of 2022, Lady T was the owner of the property. So even if we transferred the property to somebody else, be it AEP or your organization or whoever, the prosecutor can still go forward with these charges.
Right.
It's the same thing as if you owned a vehicle and somebody came and knocked the window out of your vehicle because they were mad at you as a, you know, a jilted lover or whatever the case may be, and they get charged with damaging your vehicle. Well, if you decide to sell that vehicle or get rid of that vehicle 2 months later, that doesn't change the fact that the person knocked your window out when it belonged to you. That person would still face criminal charges for it. So transferring the property alone does not just eliminate the criminal charges against Lady T. And every time the judge has asked the prosecutor, if this property is transferred to somebody else, are you going to drop the charges? And he has never given a clear yes to that question. Not one time in any hearing.
Yeah, and even last night, just so that we're clear on what's happening, it was mentioned too, you know, if there is another organization that can come in and prove this plan and things like that, you know, there could be possibility to, you know, to drop the charges and we can move forward. They can prove they have finances and things like that. Who's to say Lady T and her family don't have the finances to do that? And so as an organization, it does nothing for the CDC and our mission to have to own everything. That is not what we're trying to do. We don't need to do that. We're trying to create a stable economy here by empowering and giving resources to the people here to become homeowners, to become strong business owners, to give them the resources that they need to be successful in that. And so that is the avenue that we're trying to take now. That is not to say that we don't endeavor to own things, to create our own business structures that will support the CDC, but that is not why we're here. And that is not the solution here, particularly because after talking to Wesley, he would like to keep that in his family. And so it is our job as an organization to figure out how we can help them do that. So
right. And it's inappropriate to put your organization in the realm of saying, you know, hey, we're going to dismiss the charges if you sign over at the final hour before the hearing, sign it over to somebody else. And then, the first thing that I said when that came up to you, Ashley, was, well, is the city attorney a part of that discussion? And you heard on Monday during the motion hearing, he said, well, this is the first time hearing about this organization. Right. So if he had received an email, that's not what he said as an officer of the court on the record during the hearing that we had. Right. Yeah. And in the end, prosecutorial discretion, prosecutors hold a lot of power. You know, we say it all the time to people, you know, if you get into a domestic violence situation, once the state has picked up the charges, you as the victim can't just go and drop it off. You can't just go and drop the charges. It's the state of Michigan versus so-and-so now. The same reason that it's the city of Benton Harbor versus Lady T now. So you can't just go and drop the case. And again, as long as she was the owner on March 28th, when the ticket is issued, they can continue in the prosecution against her. I'm trying to see what AEP out of substation. Okay, good. Yes, I'm sorry. Thank you, Richard, for getting me back on track. Thank you. So what was told to me by the right-of-way agent from AEP was that they were planning to demolish all of the commercial buildings on that side of the street. And what they wanted us to sign was an easement deed. That's what they wanted from us. So that's crazy.
It's crazy for a lot of different reasons. There's no way that community deserves to just have a substation and transmission lines in the heart of the community. Like that is, and I will also add, I'm not sure if this is true or not, a lot of the commissioners and city officials last night said that this was the first that they're hearing about this plan. We were told that this is something that's been talked about in other meetings and things of that nature with and the county level. But they said that this is the first that they've heard about it, which to me is completely unacceptable.
Yes, the very bright and colorful infographic that was sent to me had a timeline that began many years ago. And even the bailiff at the court, when I brought this up to the court and talked about this, said, "Oh yeah, I heard about that. There were meetings, in my community in regards to this, substations coming up and the replacing of these lines." So if nobody in the city of Benton Harbor, any city Benton Harbor official knows about this, either they're being purposely cut out by AEP or somebody's not telling us the truth. Either of those options is not a good option for the citizens of Benton Harbor and the people who care about the city of Benton Harbor. So I don't know if they plan on demolishing those buildings and building a substation right there at that particular location, or if they just want the area to be open so that they can put additional lines. I don't, I'm not an electrician. I don't know what all of that is. But what they told me was they wanted to demolish every commercial building on that street. And when I made my first post and I asked if the owner of the Sharks building, the smaller Sharks building, before they moved across the street and then moved to the township, the very first one, the little walk-in one that now has been demolished. And I don't know the history of how that got demolished. When I asked if that location had been ticketed, I wasn't asking that just to be funny or to be petty. I was asking that because the people, from my understanding of who are currently represented by the public defender's office and my client and the cases that I have seen come before the court, are all Black owners. And that is important to me, not only as a Black person and as an attorney and everything. It should be important to everybody. That's all who I've seen coming to the court answering on these charges. And if you want to talk about the code section of 25.2, that burned out Sharks building clearly violates several of the 12 parts of this code section. Lady T's building does not violate any of them. So why is she being charged and nobody else is? The building that you talk about that does have significant damage, according to Jay Meeks, who's been in there because AEP was contacting him to put in a bid to demolish those buildings, doesn't even have a floor.
It doesn't.
So why is it not ticketed, but then Lady T is?
Yeah.
I'm not a conspiracy theorist either, but I can only base off of what I see and what I know. Yeah. And I know who is coming to the court. I know who's been charged, and I know who hasn't been charged. And I don't know if AEP is responsible for the demolition of that Sharks building. If anybody knows, I would like to know, because, however Lady T's case closes out, the reason that I got on Lady T's case in particular is because I'm interested in this issue as a whole and in the due process for all Benton Harbor residents in regards to these buildings. I want to see the city be able to handle these properties, but I don't want it to be done on the backs of people who have tried with everything in them to be able to own property in the first place.
Right.
That's not appropriate. And there's several different things that can be done. And I would be remiss to not give what I think are some solutions, because one thing that people who know me know is I'm not just going to get up and complain and not talk about solutions. So for me, one of the first potential solutions is when you're sending out letters, the first contact should be come to the planning commission. Come to a planning commission meeting, meet with the commissioners and the people who are appointed to that planning commission, a group that actually exists, again, not this appeal board that's listed in this letter.
Yeah.
And say, what can we do? What can we do to help address the issue? There may be several different things that are preventing the family or the business owner from being able to do anything. I tell people all the time, if Hurricane Katrina had happened in Benton Harbor, we would have the same issue rebuilding that Black people in New Orleans had, because they were living in grandmama's house or they were living in somebody else's house, and they never did the proper probate paperwork in order to get the building in the proper name so that they can get a loan to fix the building or do whatever needs to be done in order to fix the building. You know, that was part of the situation with Lady T after she got sick, until she was able to get her estate planning documents in place to allow Wesley to be able to even appear and do the things for her. You know, a lot of people don't have that put together. A lot of people don't have those documents done in order to address it. And if you never did what was necessary, because you can keep paying taxes, you can keep paying a mortgage, the companies will keep taking your money. But they'll take your money for insurance, they'll take your money for everything. But if everything is all in grandma's name and grandma passed in 1992, when it comes down to it, if there's a fire or you're trying to get insurance or you're trying to refinance or get a home equity line of credit, you're going to get denied because the actual owner is not present to be able to sign the paperwork and contract with them. So they'll keep taking your money, but you don't have the ability to contract. So how many of these homes are actually in that situation? How many of these potentially blighted properties, because we could be quite honest, I don't know if they're blighted or not, because I have a whole issue with the condemnation process done by the city of Benton Harbor based on what I know about Lady T's case, and if these properties actually need to be knocked down, because condemnation does not mean that a house needs to be knocked down. Abatement, the actual definition of abatement, can be revitalizing the property, even though that's not how it's defined in their code section. So bring people to the planning commission and find out what the issues are and address those issues.
Yeah.
That's step number one before you start filing criminal charges against people. And if people are unwilling, or people can't be found, or, you know, people are hiding out, or people are trying to do deeds to change stuff into people's names to avoid problems, then yes, you deal with them at the Berrien County Trial Court level. But the majority of these cases are not situations that ever needed to involve somebody being charged with a criminal offense.
Right. Yeah. And that was something that we kind of spoke about last night as well, that, you know, these are, because of the sensitive nature of things that we talked about, there has to be more than just sending a letter to someone and saying demo a property. What are the preceding steps that led up to that? You know what I mean? And
Right.
really figuring out and ironing out what that process could look like, particularly because we know that there are properties throughout this city, particularly those downtown, that really should be on this list based on if we're comparing apples to apples, and that aren't. So
right. And a lot of this being done during the pandemic, I get it. Like, there was time to go out and post all these notices, but, you know, let's follow up and actually try to make contact with people.
yeah.
Because behind each of these buildings is a person or an entity that owns it.
Yeah.
And it doesn't appear to me that the city has done the proper engagement with the owner in order to try to remediate the issue, because that's what everybody keeps saying they want. But again, I will mention the fact that the attorney says that none of the buildings have been torn down.
Yeah.
And in the same breath, he also did not say that any of the buildings had been fixed to the standards to come out of the condemnation status. So we have a situation where none of these cases have been resolved to the point that makes it better for the citizens of Benton Harbor.
Exactly. And so if the goal, if we're going to talk about mission driven work, it should not just be, the mission should not be to prosecute people just because of this issue. The mission should be that we want to see a better Benton Harbor, and how can we realistically get that done in a way that's effective. And the solution is not to prosecute people for buildings that are not going to be torn down anyway.
And the city attorney is not just the prosecutor. That is not his only role. That is not what he has been hired by the Board of Commissioners to do. It's not just prosecute cases. There are situations where you have a law firm, an independent attorney who is just the prosecutor. So his comments at the end of the meeting were very interesting to me, because he's also the city attorney. So as the city attorney, if you really have the best interests of the city in mind to really control the issues of the buildings that have been condemned or need to be condemned or need to be abated, then it's not just prosecuting and getting convictions. It's also working with people and doing arbitration and mediation to address the issues before you have to charge them. That is not your only role and duty.
Yeah.
And so I had a huge issue with that being stated last night, because that's not accurate. As a city attorney, your goal is really to address these concerns. And as soon as you hear about something like AEP coming in trying to get people to sign off deeds and potentially demolish buildings, if you didn't know about that, then you should be following up on that as a city attorney. Outside of the role of being the prosecutor for code ordinance violations, as a city attorney, you should be concerned if nobody else who is a city official knows about that process.
Yeah. So before we close out, because I know we're approaching 8 o'clock, can you talk a little bit about the status of Lady T's case right now and what the next steps look like?
Yeah, so the motion hearing that had been adjourned several times, the judge did rule on it on Monday, and he denied my motion. I brought up several different points. Obviously, we don't have time, and most people probably don't want to hear I've talked about a lot of it, but the intricate things that I was addressing. I am planning on appealing that decision, and the court knows that I'm planning on appealing that decision. To even get to the basic level, and I don't believe that she's been charged under an actual criminal code section, much less the fact that an actual criminal code section would be appropriate. It's a lot of legalese, and I agree, and I understand that that's the case. So I do plan on continuing to appeal it. We have been set for jury trial. I have no issue also having a jury trial in this case and bringing the citizens of Berrien County to be able to hear what's going on, because I do believe that regardless of the legality of the statute, that even if it was to be construed by any court to be a legal statute, that Lady T is not guilty of it. But she still is facing these charges. She's facing these charges while she's fighting some very significant medical issues right now. And to be quite honest, to take her family's attention away from being able to deal with her treatment, to have to continue to deal with this, is cruel. I'll be honest with you, it's cruel. But that my job as the attorney is to try to lessen that burden on them as much as they can, which is the reason why I agreed to speak with you today and agreed to go to the meeting yesterday and talk about this. So that's the status of Lady T's case. But I do want to state that, again, I'm the attorney of record for Lady T, but I'm concerned about this for everybody who is facing this charge. And I want to see this get addressed appropriately for everybody who's facing criminal charges, and also for the citizens of Benton Harbor to be able to address the issue, because that's not being done with what's currently happening right now. So the status of Lady T's case is that the case is still pending. She's set for a jury trial in January of 2023, and we'll go forward with that if it gets to that point. But again, the prosecutor can dismiss this particular case at any given time or any of the others. But I'll continue to appeal it through the legal process. But I hope that you all who have been listening to this, if you see any of the same issues that I'm seeing with this, will address the city government and try to find a way to make this better for everybody who's facing it and for the citizens of Benton Harbor as a whole.
Yeah, thank you so much for taking the time to speak with us today. If there are people who know someone that this could be happening to, what advice do you want to give to them, or how can they follow up? Because everyone does not have the luxury of having Elizabeth McCree as a family friend who can then make that contact. And it really is unfortunate that a lot of people have pled guilty to these charges and really have been left out to navigate these waters on their own. So is there any advice that you have for those people?
Yes, if you know anybody in the situation, contact me. There have been people from my posts who have contacted through Facebook, either my law office page, the law office of Elizabeth L. McCree, or through my personal page. My phone number is 269-873-0208. Please text if you are able to. That is the quickest way to get to me during the day when I'm in court or when I'm doing things like this in the evening, teaching classes, things of that nature. The public defender's office, as I've stated before, is aware of this. As I stated, they currently have a case where they filed a motion to withdraw somebody's plea. So if you entered a plea without being represented, because when you come to arraignment, the public defender may be there. You may not sign up for the public defender. Prosecutor is not there. So some people pled to this without having any discussion with an attorney on either side. So if you are in that situation, please reach out to me and I can get you in contact with the public defender's office, because they are very serious about these cases as well. And the civil rights issues that are involved in this have been brought forward to some of our state and national organizations like the ACLU, and we're not letting go of this. I know the chief assistant public defender and I were just talking last night. They're not letting go of this. We want these issues to be addressed appropriately, and we believe in people's due process rights and in overall civil rights of, what's happening right now and what appears to be disparities. And that doesn't mean we want more people charged with crimes. We want the actual issues to be addressed through mediation and working with the planning commission and other avenues through the city, as opposed to bringing it over to the trial court across the river.
Yeah, absolutely. So thank you again so much. If you have questions, feel free to reach out to Elizabeth or myself. From an organizational perspective, we are not letting this die either. In addition to the work that we are doing with Lady T's family, like I said, this is something that has to be addressed from a policy standpoint in this city that we are looking to see through. And so, like I said, if you see posts, pull up, because we're going to need you. And what I've noticed is that a lot of times, in order to get something moving in this city, it's going to take residents to actually speak up about it and really stand strong behind the issues that are here if we're really going to try to create this city that we really deserve to live in. And so there's going to be more things happening as it relates to Lady T's case in particular, and really seeing forth the revitalization of this Empire Corridor. So stay tuned to my personal page as well as the Benton Harbor CDC's page. We're working on with the family on some next steps. But in the meantime, I'll also be posting an email that you all can send to the city manager's office to ask for some type of resolution in this case, because as we stated, the only compliance that we've received so far was to demo, which the family does not want to do. So want to make that clear that they do not want to demo this property, does not need to be demoed. And this is already a standing structure that could be a really great life source for that community there. So thank you guys so much for tuning in. This was really, really great. And also, before we leave, I just want to lift up Miss Beth McCree. Let me tell you, I went to the trial on Monday, and this sister is bad. She was just talking in circles around the city prosecutor. I was just amazed and in awe and inspired by you. So I just want to lift you up today and every day, because what you are doing is very, very important. And the fact that you're donating your time to this just says a lot about your character and who you are and your dedication to this work. So shout out to my Spelman sister. She made us all proud. I was sitting there yes, girl. And the judge literally agreed with everything she was saying, but would still rule on behalf of the city. Was the most bizarre thing. So
well, I appreciate that. I thank you. I am who I am because of the city of Benton Harbor and Benton Township and Second Baptist Church and everybody who poured into me to allow me to become the person that I am. So I don't take that lightly, and I take the responsibility very seriously as well. And thank you, Ashley, for all the work that you have done. You and I talked back when you were still in Maryland about what you wanted to do, and you have made it come to fruition, and you're doing an amazing job, and the organization is doing an amazing job. So I want to give you kudos as well for everything that you've been doing.
Thank you. I appreciate that. All right, y'all. Y'all have a good night. Thank you so much for tuning in. I wish it was under better. We had better things to share, but this is really, really important. So I'm really grateful that you guys took the time out to join us tonight. So thank you. Please continue to share this video with your network and stay tuned for more. All right, bye.